Good morning, everyone. Welcome to today's webinar on navigating custody issues and divorce for people with families with children with special needs. We'd like to welcome Virginia Haizlip here to do the presentation today. She is with McCandlish and Lillard. So what we're going to do, I'll just tell you, I'm Diane Monig. I'm the Director of Programs here at the ARC of Northern Virginia. What we're going to do today is all of the participants are muted. So if you have a question, please feel free to type it into either the Q&A box or the chat box, and we'll get to those questions. Virginia's going to try and answer them as they come up. We'll see how that goes. If not, we'll kind of wait until the end. Just as a reminder to all of you, this session will be recorded, and I will send out a link to the recording along with Virginia's slides. I'll probably get that to you either later today or tomorrow. All right, so with that, let's get started. Thank you.
Okay. Let me just pull up the presentation. All right, so thank you everyone for being here. I'm an attorney with McCandlish and Lillard. As Diane said, my areas of practice are in estate planning as well as family law. So I work with families in a variety of settings. I wanted to talk with you all today about some of the special issues that confront families who have one or more children with special needs as they go through a divorce or separation process. So we're going to start by talking a little bit about different process options. And the reason why I wanted to start here is because the process that you use to go through a divorce or separation may very well impact the results that you end up getting. So it's important to understand your different options and how those interact with the ultimate results. And then we're going to talk about some of the special considerations for equitable distribution, spousal and child support, as well as custody and visitation, and then touch a little on guardianship and estate planning. So when we think about process options for families going through a divorce, I'm using divorce here somewhat interchangeably with separation. A family who's not legally married may end up having custody and child support petitions, but whatever the specific legal circumstances are, the process options are largely the same. So 4 main options: litigation, which everyone has probably heard of, that involves going to court; direct negotiation; mediation; and collaborative divorce. So we'll talk a little about the pros and the cons and what does each option mean. So litigation is when the resolution is determined by a court. This tends to be the fallback process if parties can't agree to use another process, or they're in a process such as mediation or something like that and it's not successful. Usually when litigation is going on, both parents have their own attorneys. There can also be other attorneys involved, such as a guardian ad litem for children. Parties in a litigation context can reach agreement. We typically call that a settlement. But if there's no agreement, a judge will make a decision one way or the other. In Virginia, we don't have juries involved with family law cases, but it will be a judge. And we don't have control over what judge hears the case. It's somewhat luck of the draw, especially depending on which local jurisdiction you're in.
Virginia, excuse me, I just want to say you're still on the first slide on the screen.
Okay, thank you, because that is not showing here. I'm going to stop sharing and try to come back.
Okay.
And if that fixes the problem. Sure. Okay. Thank you for letting me know, Diane. Okay.
That's perfect.
Okay. So I don't know why the slideshow is not working, but we'll just look at it in the program. Okay, so we're talking about litigation. The pros are there's a timeline. You will have deadlines and you will have a resolution. So there's a light at the end of the tunnel. And sometimes that's very important because families are just not able to move forward without someone from outside imposing deadlines. There will be a resolution to your situation, of finality. And if there's a party who's not behaving appropriately, not participating, a court can compel that person to take action or to not take action, whatever may be appropriate. Of course, the downside, it tends to be the most expensive process. It can take longer than other processes. We don't ultimately have control over when a hearing date is set or when a judge makes a decision. There's less opportunity for problem solving. What I mean by that is judges are restricted by the authority that they are given in the state laws and what they can do. So, for example, in Virginia, generally child support only goes till a child reaches age 18 or graduates from high school. So even if a judge thinks it's appropriate for child support to be paid longer than that, if the statutory requirements are not met, they can't order it. Litigation can contribute to bad feelings. It can really make it hard for people to co-parent or move forward together in a family situation once they've been through that process. Once you've heard someone in a courtroom say really bad things about you, it's hard to really come back and deal with that. So for some of these reasons, generally litigation is a last resort for most families. It's the solution that we look at when nothing else is working. Direct negotiation. What I mean by this is negotiations not necessarily directly between the parties. It can be through their attorneys, but just exchanging proposals back and forth. It can include informal disclosure. That's something that happens in almost all divorce cases, is that there's an exchange of documents and information back and forth to make sure that people have the information that they need to make a decision. And lawyers can be involved, but they're not required to be. So if someone doesn't want to have an attorney or the couple feels that it's not necessary for both of them to have attorneys, they can choose not to. In Virginia, one attorney cannot represent both spouses, but there is no requirement that both spouses have an attorney. So it gives you a little more flexibility. Tends to be the least expensive process. It's just limited to the cost of your attorney's time. If you choose to have an attorney, you have control and you have flexibility in terms of both the timing and the solutions. That can be a pro and a con, because if someone's not participating in the process and it's just a voluntary negotiation, there's nothing that we can really do to force them. Using this process, especially if there's no attorneys involved, you may not be making an informed decision. You may not even be aware of the implications or the legal requirements of what you're trying to do. You may not have all the information that you need. Informal disclosure is not perfect. If someone is hiding assets or not revealing income, that can be missed in this process. If people wind up writing an agreement themselves, it may not comply with all the legal requirements. It may not say what you think it says. We deal with these cases a lot in a litigation context where an agreement is poorly drafted or is not as clear as the parties think it is. And that ends up costing a lot of money down the road dealing with it. So that can be a negative side. Mediation resolution is determined by the parties, but it's facilitated by one or more impartial professionals. A mediator is usually a trained professional who facilitates the decision making. In Virginia, there is a process for attorneys to be certified as mediator by the Virginia Supreme Court, but it's not required to have that certification in order to act as a mediator. It's also not required that you be an attorney in order to act as a mediator. So typically we see attorneys, retired judges, and mental health professionals all acting as mediators. People like mediation because it's private and confidential. There are laws governing mediation that say what's discussed in mediation can't be revealed elsewhere. So if you make a settlement offer in mediation, you can't be asked about it in a court hearing. It's voluntary. So both people have to agree to it. And if you don't want to continue, you can stop. One of the really positive things about mediation is it allows for creative resolution. What I mean by that is because a judge is not making the decision and you're not limited by the authority that the judge says, you can reach an agreement that works for your family that may be outside the box or something that not everybody does. But if it works for your families and it's legal, that's fine. You can have input from other professionals. So if you're going through a mediation process, you can have an attorney advising you. You can have a therapist advising you. Those people can participate in the mediation process, either directly in it or as outside advisors. Some of the cons, a mediator does not offer legal advice. So if you're going through mediation and you don't have your own attorney, a mediator ethically should not be telling you, that's not a good deal for you. I don't think you should do this, anything like that. Mediator cannot compel a person to act or to disclose information. The expectation is that both parties are coming in and disclosing material facts. But if they don't do that, there are very little remedies that the mediator has to fix that situation. Sometimes for families who have difficult family dynamics, mediation is not a good fit because they're not able to negotiate effectively together, not able to have a conversation, even with a third party in the same room, and it's just not a good fit and they're not able to reach an agreement. So the last process I wanted to work through and discuss with you all is collaborative divorce. In this process, there's a professional team of individuals who have all been trained in the collaborative process and who work together with the couple in order to reach a resolution of the issues. Collaborative divorce is also private and confidential, as with mediation. And in a collaborative process, the parties typically sign a collaborative participation agreement that governs the process, and it requires things like full disclosure, a commitment not to go to litigation, a commitment to maintain certain financial and other obligations while the process is ongoing. So essentially, there's a structure as the couple works through the process. So you do have the benefit of having multiple professionals guide you through the process. As I said, you can have lawyers, mental health professionals, financial neutral, can even have other experts such as a physician or a real estate appraiser, really anyone who might have knowledge that's useful. It's also private and confidential. As with mediation, things that are discussed in the collaborative process cannot be used in court if the parties are unable to reach an agreement. And this process is really set up to help parties discuss things between themselves, which we hope will be something ongoing that they're able to use once they're done with the process. It can be more expensive than some of the other processes, such as direct negotiation or mediation. It typically still is less expensive than litigation. If you're unable to reach an agreement, the professionals that you've hired are disqualified, meaning a lawyer who represents you in a collaborative process cannot later represent you in court if you're not able to reach agreement. Because of all the professionals that are involved, it can be a little difficult to get meetings scheduled and have people move through the process as quickly as they might otherwise like. So sometimes there are scheduling challenges or people feel that it takes a little longer than they were expecting. So use of these processes is not necessarily one without the other, meaning if you're in a litigated case, that doesn't mean that you stop negotiating. Sometimes, for example, people who are in litigation will even schedule mediation to try to resolve their issues before their trial date. So as you're going through the process, it's important to talk with your attorney about what's best for you and your situation. The reason why I wanted to start with these processes is because a lot of families who have a child with special needs, litigation is not going to be the best choice for you. Because litigation does tend to be less detail oriented, less opportunity for individualized solutions. So if that's what you're looking for, some of the other processes may very well be a much better fit for your family. And it's important to have just some kind of working knowledge of that as the case gets started. So the basic requirements for divorce: if there are minor children, the parties must be separate and apart for at least a year. If there are no minor children, you have to be separate and apart for at least 6 months and have a signed agreement that resolves all of your issues. These are the requirements for a no-fault divorce. Virginia does still do fault-based divorce. That tends to be much less common, so I just focused on the no-fault requirements here. And if you have questions as we're going through these, you can put them in the question and answer. Otherwise, we'll keep going and we'll have time for questions at the end also. So equitable distribution. This is what we think of in terms of dividing up the assets and liabilities between the parties. As we go through this process, the court or the parties have to classify value and divide the assets. In Virginia, we have 3 primary designations when we think about assets. They can be separate, meaning they belong entirely to one party and the other party has no claim on them. They can be marital, meaning they belong to both parties, or they can be hybrid, meaning they have some of each. So a classic example of a hybrid asset would be if one person owns a home before the marriage and they sell that home and use the proceeds on a down payment for a home that's purchased during the marriage. That would be a hybrid asset because the house that was owned before the marriage is separate, but then they've taken the proceeds and used that as a down payment to purchase a new asset that does have a marital component. So that would be a hybrid asset. You could also think about, for example, a retirement account that someone has before they get married. So they have money in their 401k. That's their separate property, but then they continue working and they continue contributing to that retirement account. So now it's a hybrid asset because it has both marital and separate property. In Virginia, the law says the assets are valued as of the date of determination, meaning the trial date, unless there's good cause to value them another date. What we see most commonly is that each party receives 50% of the marital assets and liabilities. But I wanted to be really clear that this is not a legal presumption, and certain circumstances may make it appropriate that it's a different than 50-50 division, or that it's not 50-50 of each specific asset. And that certainly may apply if you have a child with special needs. Some of the things that I thought of, for example, may be more important for one person to retain a marital residence if a child is enrolled in a specific school or program based on where that home is, or if the home has been modified to meet the needs of a child, if it's been made wheelchair accessible, for example. It may be appropriate that there's a deviation from 50-50 if circumstances make that work for the family. And you can also consider essentially horse trading or offsetting one asset for another. So looking at trading value in a bank account for real estate rather than dividing everything exactly equally. This is a very case-specific determination. So if you're going through this process, it's important to really start by having a good idea of what everything is, and then moving forward from there in terms of what makes sense for the family as a whole. Okay, so we had a question about if there's absolute proof of adultery, does adultery have any influence of the ruling in the rulings of the judge? The answer is yes, it certainly can. Where we see adultery coming into affect the case is really two main areas. It can affect equitable distribution. If there's adultery in Virginia has to be proven by clear and convincing evidence, which is beyond the normal preponderance of the evidence standard in a civil case. So if you've proven adultery, and you can also show that marital assets were used to essentially pay for the adultery, we can see that that will affect the equitable distribution. So maybe instead of being a 50-50 split, it's 60-40 or 55-45, something like that. It also matters in terms of spousal support. For the person trying to receive spousal support, adultery is a bar, meaning if you've committed adultery and the other person can prove it, you may be prohibited from receiving spousal support. On the other side, if it's the person paying spousal support who's committed the adultery, that can affect the amount or the duration of the award. So we still see that adultery is an important factor if it can be proven. It's a high burden of proof, but it certainly can affect cases. So that leads us right into spousal support. It can also be called alimony. We tend to call it spousal support in Virginia. It's a payment from one spouse to another to provide for the recipient spouse's needs. So child support is separate. This is intended really just for the spouse's needs. It can be lump sum, meaning paid all at once, or periodic. Certainly we see periodic or monthly support far, far more likely. There are about a dozen factors that a court has to consider in making an award of spousal support, but some of the most important are the length of the marriage, both spouses' income and expenses, the age and the health of the parties, and the earning capacity of the parties. So I've listed one of the factors here in the spousal support code. Virginia Code 20-107.1 is where we see the factors that the court has to review. But one of the things the court has to consider is whether there's a special circumstance of a child or of the parties that would make it appropriate that a party not seek employment outside of the home. For example, I had a case where the parties had 3 children. One of their children had very significant disabilities, and for that reason, the mother was really not able to work outside the home at all. And in that case, she ended up having indefinite or lifetime spousal support because it really was not possible for her to work outside the home and meet her child's needs. And I think given the other factors in that case, she probably would not have had indefinite spousal support, but that ended up being a significant issue for the judge. So that's certainly something important to consider. Let me see, we have just checking the questions. It looks like we're fully caught up. All right. So child support is a payment from one parent to the other to provide for the needs of the party's children. In Virginia, we do have guidelines that are used routinely to establish the appropriate amount of child support. And the information that's input into those guidelines comes from both parties' monthly income, cost of providing health insurance, cost of work-related childcare, the amount of custodial time that each parent has. If a parent is paying child support for one or more other children, or if there are other children not of the marriage, that can also affect the guidelines. Those are the basic inputs that go into the guidelines. However, as with spousal support, if you have a child that has disabilities or special needs, that can also affect the child support number. So Virginia Code 20-108.1 sets out the reasons a court could deviate from the guideline child support number. What we mean by that is the court would look at what the guideline number is and then decide that the amount of child support should be either higher or lower because of a specific reason. And so one of the factors that the court has to consider is if a child has special needs as a result of physical, emotional, or mental condition. So it may be that a court decides that the guideline amount of support is insufficient because of a child's special needs. Anytime a court is making a child support order, they also have to address the provision of health insurance and payment of unreimbursed medical expenses. The default arrangement under the law is that unreimbursed medical expenses are paid proportionally by the parents, meaning if you make 50% of the income, you pay 50% of the unreimbursed medical expenses. And typically those are just paid by one parent reimbursing the other after an expense is incurred. However, if there are significant ongoing medical expenses, parties may agree or court may order another arrangement, such as a regular monthly amount or deviating upwards from guideline child support to meet those expenses. So that's certainly something important to consider as you're making a decision about child support. Also wanted to focus especially on ongoing child support. So in general, without a court order otherwise, child support terminates when a child either reaches age 18 or graduates from high school. However, a court can order ongoing child support if a child meets these three criteria, and it has to be all three. They have to be severely and permanently mentally or physically disabled, and the disability existed prior to age 18 or graduate from high school. They have to be unable to live it independently and support themselves, and they have to be living in the home of the parent seeking or receiving support. If you have a child that meets these needs, you can certainly negotiate when you're going through the child support determination that child support will not terminate when it normally would. You can also have a circumstance where once the child reaches this age, you go back to court and you specifically ask the court or reach agreement with the other party for child support to continue past the normal age at which it would terminate. So if the parents don't agree about whether or not the child is disabled, this may involve using expert witnesses or getting medical opinions to show that, yes, this child does meet the disability requirements. One thing that you want to really think about if you do have ongoing child support is how is this support going to be paid? If the intention is that the child with special needs will apply for Social Security, you really want to think ahead about having that child support paid to either a special needs trust or an ABLE account, and that needs to be addressed in the order. If you have it addressed in the order, then you can avoid having it treated as income and reducing that child's SSI award. So again, this is something that a court can order, and I have been successful in sort of educating judges and having that included as part of a court order. But if you and the other parent are on relatively good terms and you're able to work through this and have it resolved outside of court, that can really be helpful in making sure that the child support order is properly drafted and the child support is paid in such a way that it maximizes the benefits that the child can otherwise receive. Okay, so this question, what about if a spouse worked at a decreased number of hours? What if that spouse still qualifies as a high wage earner? For litigation, what can the judge rule on? Okay, so I'll answer, there's two questions here, two or three really. So when we're thinking, and I think these really relate to spousal support, when we're thinking about spousal support, the threshold question really is income and need. So if a spouse is the lower earning spouse still has sufficient income, even though they're working decreased hours, they may not necessarily be a spousal support candidate. it really is a fact-specific determination. The next question is, for litigation, what can the judge rule on estate planning to set aside money assets? The judge really has little to no ability, excuse me, to require parties to make any estate planning provisions. So if that's important to you, that's something that you can do by agreement. And certainly a marital settlement agreement can require spouses to set up an estate plan, including a special needs trust, for example. But that is not something that a court can order as part of a divorce case or a child support case. And that's why I wanted to start talking about processes, because if you're interested in making those kind of agreements, you really need to look at something outside court that will allow you to have an ongoing dialogue with other parents so you can reach some of those creative solutions and make sure your children are provided for. Excuse me. Okay. So moving on to thinking about child custody and visitation. This pertains to children under the age of 18. There's really two main components when we think about custody. Legal custody, which involves decision-making for major issues, as well as physical custody, caretaking, who's actually physically caring for the child at a different time. There are several factors that the court has to consider when they're making this determination, and we call these the best interest factors. I highlighted some of the most important: age and the health of the children, each parent's prior role in caring for the children's preference, parents' ability to work together to make decisions, parents' current relationship with the child. There are several factors that the court has to consider, and they're very broad, but I wanted to highlight some of what we see typically as the most important. So some of the most important considerations, if you have a child with special needs, legal custody. In other cases, this may not be as crucial to consider, but for families of children with special needs, we see a lot that they have to make ongoing, very important decisions for their children. They're dealing with the schools and setting up IEPs. They're dealing with doctors in making decisions about medical care. Maybe they're making decisions about other programs or activities that the children participate in. And it really requires a significant level of involvement and self-education. So it may be that an arrangement beyond the typical joint legal custody is appropriate. Maybe one parent has final decision-making, or maybe one parent has sole legal custody for education decisions. Perhaps you have a mechanism in your agreement of what you're going to do if you can't reach an agreement on an issue. We may want to think about specific sort of customized schedules for a child that has special needs. There's no such thing as a default schedule in Virginia anymore, but there are certainly schedules that are very common. But it may be that a child with special needs, it's really not appropriate for them to have overnight time at the other person's home, or something like that. If there's more than one child and they have very different needs, it may be that it's more appropriate for them to have different schedules. That's not something we would typically see in a case, but that may very well be the solution that makes the most sense for your family. You may need to have very detailed provisions regarding requirements for living arrangements, if there's going to be caretaker involved, perhaps requiring that both parents participate in a child's therapy or ensure that a child attends therapy. Again, these very detailed, nuanced arrangements are typically things that we see in an agreement that's reached outside of court. Judges typically have limited bandwidth to dig down in the details and get into all these provisions. So these are things that we see more in something that's done in mediation or a collaborative process or something like that. So we have a couple of questions that we'll answer before moving on to guardianships. Okay, if one non-custodial parent is behind in his payments, is this still considered income or it becomes back payments to a custodial? Okay, so this is for a child over 18, and essentially it sounds like the parent, we would say they're in arrears. That should not be income to the child because it's still owed to the custodial parent. So it shouldn't be the same as ongoing child support paid. Okay, so guardianships, this pertains to adult children, typically over age 18, but you can file the petition as early as 17 years, 6 months. Some of the things to think about, excuse me, if there's a divorce situation, there may be custody provisions, either in their agreement or in their final order of divorce, that need to be included or will inform the guardianship process. A guardianship process is a completely new case. It's not part of the divorce case between the parents. It's not part of the child custody case. If there's a custody case in the juvenile court, it's a new case. And essentially starting from scratch. If there's a guardianship in place and the parents divorce, you may want to consider whether that guardianship order needs to be modified. So a lot of times parents will have an order that makes them co-guardians of their adult children with special needs. If they then get divorced, they may want to consider whether that guardianship order needs to be changed or whether they want to leave it in place. You can think ahead about it if your child is younger than 18 and address it in a marital settlement agreement, but you still need to file a new case in order to have a guardianship order entered. So there's a question, they have joint legal custody, but sole physical custody are both legal guardians. Okay. So for this person, this is a pretty fact-specific question, and I encourage them to speak to a specific attorney and get advice that's appropriate for their situation. I can't really answer individual questions in this format. I'm happy to answer questions offline, but I want to be sure to respect everyone's confidentiality. So if you want to ask a specific question, just please get in touch with me after. Okay. So estate planning considerations. This goes back to a question that was asked earlier. You can address this in a marital settlement agreement. You can have a provision that requires both parents to do their estate planning. And ideally, if you anticipate that a child will qualify for SSI and or Medicaid, you would want a requirement that either the parents are going to set up their own special needs trust or there'll be a joint special needs trust for the benefit of that child. Again, ideally, if this can be reached by agreement, think about who's going to serve as guardians for the child if neither parent can do it. Regardless of whether or not it is addressed in the agreement, it's really important that once a divorce is finalized, both parents update their estate plan to, at a minimum, include a will, a power of attorney, and an advanced medical directive. You know, a lot of times people get through the divorce process and they're kind of burned out and overwhelmed. But not doing your estate planning can lead to some pretty significant unintended negative consequences for your family. So it's really helpful to at least have these minimum documents done once your divorce is finalized. Probably a lot of you are familiar with special needs trusts, but again, these allow the beneficiary to maintain their qualifications for Social Security, Medicaid, and other benefits. You need to think about whether it's going to be a third party, if it's the parents' money that will be benefiting the children, or first party. If it's the child's own money, we need to think ahead to getting these approved by Social Security and Medicaid. And remember that these are intended to be supplemental to the beneficiary, and that they don't preclude you from using an ABLE account. And an ABLE account can be a very helpful device, especially if we need a place for our child support money to go. It can go to an ABLE account for a child over age 18 who still qualifies for child support. And that way you can really maximize, again, the income that child receives. So we have one more question in the chat. Okay, so this person is asking about Maryland family law. Is it best to go through litigation to get child support for an adult child? I'm not licensed in Maryland, so I wouldn't be able to address that issue. Again, I encourage you to speak with an attorney who is licensed in Maryland. We have time now for any questions, so I will stop sharing. And if there are any other questions, will we still see them? We'll see them in the question and answer. Okay.
Yeah. Virginia, I have a question. For the
Sure.
child custody payments, does that go into a first party trust for the child?
If they're over 18,
Yes.
yeah, it would go into first party special needs trust. We answer most of the questions as we were going, so people may have already had all their questions answered, but I wanted to make sure to leave some time for any follow-up questions.
Does anyone have any more questions? You can put it in the Q&A box. I will send out additional information also on our special needs trust program. If you have any questions, and we just recently had a webinar from Able Now, so I'll share the link to that as well.
Those are great resources. I think we answered all the questions.
Oh, I see some.
Okay. Do I need to contact another parent? Okay, to make a change. I'm not quite sure what this question is getting at, but in general, yes, if you want to make a change to your agreement or to an order, you will have to contact the other parent. Someone asked about supported decision making. So supported decision making, this would be for an individual with special needs, but who perhaps doesn't qualify as being incapacitated to have a guardianship. So this is the idea of identifying sort of advisors who can help the child make decisions and having the child sign onto documents like a power of attorney and an advanced medical directive. This is something that is done with the child. So if that's something the parents anticipate, it can certainly be something that's part of a divorce. You won't be able to resolve that completely in the divorce process because it involves another client, the child. But this is something where if you have a good dialogue between the parents and way of making decisions, can really help that process of supported decision making for the child. So we answer that. The ABLE account, those are specific accounts that are allowable for individuals with disabilities that are not included in their income or assets when we're thinking about qualifying for Social Security and Medicaid. The nice thing about ABLE accounts is the money in those accounts I'm sorry, I lost my train of thought. The money in those accounts can be used for more purposes than a typical special needs trust. So they allow for a little more flexibility. Okay. All right. So the person clarified if they wanted to be able to have the child support payments sent to an ABLE account, yes, you will need to contact the other parent because that needs to be included in an updated order. So you need to involve them as well as have a new order entered. So what options does a parent have for maintaining a role in educational and medical decisions during the separation period before the divorce is final? Um, so absent a court order or a written agreement, both parents are presumed to have equal custodial rights. If that's not happening, it kind of depends where you are in the process. Whether that's something that can be remedied somewhat informally by talking to the other parent saying, hey, I want to be involved, or perhaps you need a temporary court order. It depends on your specific circumstances. Is there a list of clauses? There's no specific list. It really is fact specific, and it depends on your family's needs. Okay, so someone else has a question about in-laws, ex-in-laws taking care of the child. Again, I would just encourage you to speak with an attorney to get legal advice about your specific case. So we'll have to hold off on that. Somebody asked about the maximum contribution per year for able accounts. That's tied to the gift tax exemption. So I believe that's gone up to $18,000 this year, but yes, there is a limit. Child support is payable through DCSE. So you really need to contact the other parent. This person's asking how to make the money go to the ABLE account without contacting the other parent. You have to update your order, which will involve some contact with the other parent. You could put the money in the ABLE account, but it would still potentially count against their Social Security. And then someone asked, how does my 16-year-old fit into putting her input for visitation? This will depend what process you're in. I've had circumstances where if it's a litigation case, children have actually gone to court. If it's another process, like in a collaborative case, the child can speak to the mental health professionals and let them know that her input informally. So it depends a lot on what process you're in and what the child feels comfortable doing. I think those were the last few questions.
We have another few minutes. If anyone has a question, feel free to put it into the chat, into the Q&A box. I did just type into the chat along with all of the information today. I'll also include information on ABLE accounts, special needs trust, and also supported decision-making, since there was some questions about that as well.
That's great. We have to go through that a little quickly, so that will be helpful.
No other questions?
Last time I said I thought we were done, we got 5 more. So,
so we'll give it another minute.
Okay.
And if not, we will let you go. Virginia, thank you so much for all of this information. This was super helpful. These are questions we get asked often here at the ARC.
You're welcome. I'm glad it was helpful.
To those of you who listened in, please feel free to reach out anytime with questions. Oh, I see one more question in the Q&A.
It was just a thank you. So you're welcome. Great to be here with all of you.
All right. Well, with that, we'll let you go, I think. Thank you, Virginia.
Thank you,
everyone.
and have a good afternoon.
Bye-bye.